Good evening and welcome to Making the Case. I'm Yodit Tewolde. Emotions ran high today in the Kenosha, Wisconsin courtroom where Kyle Rittenhouse took the stand in his own defense. He faces several charges tied to the August 2020 shootings that killed 2 men and injured a third during a Black Lives Matter protest. In what was likely the most pivotal moment of this trial, Rittenhouse comfortably and confidently walked jurors through that fateful night. But when he got to the part of the actual shooting, Rittenhouse visibly broke down. And when the prosecution had its chance to question Rittenhouse, things got heated. Joining me now to discuss all of the action is former president of the National Bar Association and CEO of the CK Hoffler Firm in Atlanta, CK Hoffler. Also with us, former prosecutor and senior attorney at the Atlanta Personal Injury Law Group, Titus Nichols. Thank you both for coming on tonight. Let's get to it, all right? It's a rare thing, guys, to see a defendant taking the stand. So when Kyle Rittenhouse did, all eyes were on him, and not just from those gathered in the courtroom gallery. We're talking about the whole country was watching this televised trial. CK, to you first. How did Rittenhouse perform on the stand under direct examination?
I think, quite frankly, he performed beautifully for his defense. He looked like an innocent little boy, almost a cherub angel. And when he broke down and cried, he probably pulled at the heartstrings of most people, most mothers, and certainly the jurors. And I think that he was, even though what he was saying made no sense, I think that he did a good job for his own case. But I must underscore, what he said made no sense. But he did a good job for the defense of his case from the standpoint of, the prosecution versus defense. But it made no sense.
Well, we're going to get to his actual testimony in a few. Titus, I want to get your thoughts.
I agree with Attorney Hoffler. I mean, it was a beautiful, heart-wrenching performance, and I'm pretty sure he and his legal team went over it several times before he took the stand. Even down to wearing the ill-fitting suit so he could really appear to be just a young child who really didn't understand what he was doing. But when you look at the facts of the situation and you contrast that with his breaking down and crying, while yes, you might feel bad for him for crying, but I don't feel that it really shifted the narrative or shifted the facts of what took place.
Well, let's watch that moment when Rittenhouse broke down crying on the stand.
And I was cornered from in front of me with Mr. Zeminski. And there were three people right there. That's what That's what I run.
There wasn't a question in my mind about whether Rittenhouse was going to cry on the stand. The question for me was whether his tears were going to be genuine. CK, was this an Oscar-worthy performance or genuine emotion?
I think it was a combination of both, but I don't think that he broke down and cried out of the genuineness or feeling some sense of remorse. I think he broke down and cried because he did, after all, kill 2 men and injure a third. He had all the reason in the world to cry. That's heinous. That's awful. That's disgusting. So there are many reasons for him to cry, and he's sitting in a trial. But I did also believe that it was an Oscar-worthy performance that I believe he probably rehearsed. This was a calculated risk to have him on the stand. And he is an 18-year-old boy, that's true, but he committed a grown man adult crime, and he knew what he was doing.
Mm-hmm. Well, the judge had to call a 10-minute recess to give Rittenhouse a chance to gather himself. Titus, how do you think that this display of emotion will go over with the jurors?
That's the $64,000 question. It really is unknown what's going through the juror's mind. You have lawyers who have been in the courtroom before who look at it and see it as a performance, a Oscar-worthy performance. But then you might have some jurors who might look at the crime and think, well, maybe he's demonstrating remorse. Maybe this is such an emotional situation, it's getting to him. It really depends on how the jury views his crime. Do they see it as simply him trying to get sympathy? Or do they see it as, well, that could be my son or my nephew sitting there in the chair?
Yeah, and it definitely, there was a split screen too showing his mother in the gallery who was visibly emotional as well. And that could also play a role on this jury. All right, guys, this was a moment I was anxiously waiting for. Cross-examination by the prosecution. Watch this exchange between Assistant District Attorney Mr. Binger and Rittenhouse.
In this moment, you told us Gage Grosskreutz is a threat to you right now.
Yes.
He's got a pistol not aimed at you. You've got an AR-15 aimed at him. Why is he more of a threat to you than you are to him?
Because he was moving at me with a gun in his hand.
This is right after you've killed Anthony Huber, correct?
Yes.
Right after you fired 2 shots at almost point-blank range at the man running towards the camera right now and missing him, correct?
Yes.
And you're telling us Gage Grosskreutz is the real threat at this moment?
All right, so CK, this was about the lone survivor of the shooting who actually testified in court that he pointed a gun at Rittenhouse, essentially bolstering the defense's case for self-defense. But here the prosecution made a point that Rittenhouse, he just couldn't concede to, that if he thought that Gage was threatening with a pistol at his side, wouldn't Gage think that Rittenhouse was threatening with his AR-15 pointed at him? Was this a point for the prosecution?
I think it was a point for the prosecution because what Rittenhouse said made no sense. He had an AK-45. He had an assault weapon. He had already killed 1 person, 2 people, and was just rabid, quite frankly. So I think it made no sense, although I do think because the defense is painting this picture that there was so much pandemonium and chaos that Rittenhouse really just, was part of the pandemonium and chaos, and he was defending himself. It makes no sense. Kyle Rittenhouse injected himself in this picture. He injected himself in this movie. He injected himself with an assault weapon. He injected himself as the only person who killed people in the entire protest. So now it's easy for him to sit back and say, well, I felt threatened. What? You injected yourself in this whole movie, and he should not have the benefit of using self-defense as a way of getting out of a picture that he injected himself into.
Well, the prosecution then tried to turn our attention to intent, Rittenhouse's intent that night. Take a listen.
Everybody that you shot at that night you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them?
I did what I had to do to stop the person who was attacking me.
By killing them?
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force?
I used deadly force.
That you knew was going to kill?
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
Titus, he made a good witness there. I mean, he said an answer, he stuck to it, but sometimes when you can be so prepared, you just can't concede to certain things that are just so obvious. What did you think was going to happen if you stick a gun to someone's chest, point blank, and shoot?
And I think that's really the entire focus of the whole trial, is the fact that this all happened because he illegally obtained a firearm, because he crossed over state lines, because he joined up with some hodgepodge vigilante group to protect property that he did not own. So when you do all that, when you wave around a match, around gasoline, you can't claim surprise when a fire erupts. What did he think was going to happen walking around with an AK in an area that there was a protest going on? What did he think was going to happen? And it goes back to some of the questions the prosecution asked today, in which he pointed out, why did you bring a gun with you? You clearly knew there was danger. You clearly knew this was a situation where there might be violence. So why would you bring a gun with you if you weren't intending on using it? And I think that's what the prosecution needs to drive home, is that Kyle crossed over state lines into that city with the intent to use that firearm on somebody.
And also made the point of why bring a gun if you intended to just help people, to provide medical assistance. All right, guys, we've barely scratched the surface about all of what went down inside that courtroom in Kenosha. So when we return, we're going to get into that intense moment when the judge and the prosecutor went head to head. You're watching Making the Case. 18-year-old Kyle Rittenhouse took the stand today, marking the first time he's spoken publicly about the night he shot and killed 2 men and injuring a third in Kenosha, Wisconsin. Still with me, CK Hoffler, former president of the National Bar Association, and former prosecutor Titus Nichols. All right, guys, before we get into more of Rittenhouse's testimony, let's go back to the start of the prosecution's cross-examination. The prosecution's lead attorney, Mr. Binger, wasn't even 5 minutes in before the judge intervened, which led to this intense exchange.
You've also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
I'm going to ask you folks to go in the library for just a second.
Your Honor, I don't want to jury here. He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now that you have...
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right on the borderline, and you may be over.
CK, I just started laughing at that moment because I just knew that there was so much more that was coming from this judge. But why would Binger take this route? I mean, talking about being coached in preparation to take the stand, sure. But to go as far as he did, to question why he said nothing pre-trial, it's just not smart. So, you know, especially when there was so much more he could have gotten into.
Bad move, bad strategy. The judge has already demonstrated that he was, in my impression, a little bit more defense-oriented. He was upset, he was banging on the desk and all of that. And so I think this was a bad strategic move that was completely unnecessary. There were so many other areas he could have really nailed Kyle Rittenhouse on from the inception. But instead, and you know what's really interesting, jurors, I've been in a position I tried a case for 97 days with a judge who had a very similar temperament or worse. And jurors pick up on that temperament. They feel and sense where the judge favors one side or the other for whatever reason, and it can backfire. But in this case, the prosecutor had so much more that he could have done and start off with. You want to start off with your best stuff, things that you know you can knock out of the ballpark, not give the other side an advantage, have the judge all mad at you. So that was a bad strategic move. I agree with you, Yodit, and he really should have done something different. Use the other 100 areas he could have gone into with Kyle Rittenhouse, who, after all, was a defendant taking the stand when he paraded through on a street with an AK. There were so many other things he could have.
You know, and the prosecutor actually started getting into those things, but at that point, the judge's patience was already wearing so thin. Now, about a half hour later, the judge asked the jury to leave again from the courtroom after the prosecution questioned Rittenhouse about a matter that the judge had previously ruled couldn't come in. Watch.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished. By the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me.
Don't get brazen with me. Titus, this is a seasoned prosecutor who's presumably tried hundreds of cases and understands the rules of evidence. So he knew better than to get into something the judge already said he couldn't, especially after he was lit up by the judge just 30 minutes prior. But so for some, it seemed like Binger was throwing the case on purpose to get a mistrial, which would mean that he could get another chance at retrying this case. But I don't think he would go that far. I just think he knows he's losing and is trying everything he can to just salvage his case. What is your take?
I think Binger recognized that the judge doesn't like the way he's prosecuting this case. However, sometimes the prosecutor, you got to dig your heels in and stand up to the judge. And when the judge starts yelling at you, you need to respond in time and let the judge know, I understand the rules of evidence, and I'm going to try my case in a certain way. And if that makes the judge even more upset, then you have to decide what's more important, trying to keep the judge happy or you proving your case. Because at the end of the day, the prosecution has the burden of this case, not the defense. So the prosecution has to question Kyle on particular parts of evidence. The prosecution needs to demonstrate that Kyle's defense doesn't hold up under scrutiny, even if that means getting yelled at by the judge. Like I said, sometimes you have to dig in your heels. As a former prosecutor, there were times when the judge would yell at me, but I would continue to focus on proving my case because at the end of the day, what's the judge going to do? It's not like the judge is going to take out a belt or something like that. The judge is going to yell at you. You need to focus on convincing that jury.
Well, you know what, Titus, I'm glad you said that, and I hope my team is actually listening to this because we had this discussion earlier in a team's meeting, and I was the only one saying, what was this prosecutor supposed to do? I thought he was really respectful as much as he could be while trying to assert his point, and the judges wouldn't let him continue. He has to do his job. All right, CK, you mentioned that, in your opinion, the judge sort of seemed favorable to the defense. I couldn't agree with you more. He's been showing bias, I mean, from his pretrial rulings that are favorable to the defense to his demeanor towards the prosecution, interrupting the prosecutor's cross-exam of Rittenhouse and making arguments on behalf of the defense. Look, I agree with his admonishment of the prosecutor's disrespect of the defendant's right to remain silent in his rulings, but he's definitely not giving the defense the same energy he's giving the state.
I agree. In fact, and I think the jury is probably noticing this, and it can backfire. Whenever that happens, and I have ultimate and infinite respect for judges, but whenever it does happen where a judge does appear to be biased, in my personal experience, it backfires on, and the jury starts to feel actually some sympathy towards the attorney or towards the side that the judge is being very, very tough against, unnecessarily so. And it's so evident in this case that I think it's very evident. I think it's going to ultimately help the prosecution, but they have some other battles. They have so many other battles, quite frankly. But that's just to boot. You've got the judge who was, in my impression, making rulings and giving body language that shows his annoyance towards the prosecutors.
All right, guys, next, we are going to go into the defense's request for a mistrial. Will they get one? We discuss when Making the Case returns. After an intense day in that Kenosha, Wisconsin courtroom, the defense attorneys for 18-year-old Kyle Rittenhouse filed a motion for a mistrial. Back with me, former president of the National Bar Association, CK Hoffler, and former prosecutor Titus Nichols. All right, so the defense made a request for a mistrial with prejudice, which means the state wouldn't be able to retry Rittenhouse again on these exact charges. Now, initially, while I was watching this trial, I was thinking to myself, the defense had plenty of opportunities to ask for a mistrial. Maybe they're not because they know that they're winning, and why give the prosecution another bite of this apple? But they've asked now for it to be granted with prejudice. Titus, are there grounds to grant their request?
It depends on who you're asking. Of course, defense is always going to say that they have grounds. That's why they raised the motion for mistrial. Defense would say that every time they ask for a mistrial, that should be granted. Now, whether the judge is going to take the ultimate step and actually grant it is a totally different ball of wax. Because if he grants it with prejudice, that means he is saying that the state intentionally did something to provoke the mistrial, and thus they cannot re-indict Kyle and prosecute him again for these murders. I'm not sure if the judge wants to go that far. It's one thing to yell at the prosecution in the middle of the cross-examination. It's something to totally torpedo the case and allows a alleged murderer to walk free.
CK, your thoughts?
I tend to agree. I mean, I think the defense moving for a mistrial with prejudice is wholly unrealistic. I think the judge is upset, he's tired, he's mad, he's disgusted, but that would be something that is relatively novel in jurisprudence to grant it with prejudice. The conduct does not rise to that level, and I think that he would suffer the ire of the entire legal community if he did that on a case of this magnitude. After all, there was a young 17-year-old who lied repeatedly about so many things and who was in violation of the law, walking through a street with an AK-47 and killed 2 people and injured a 3rd person. That would just really defy common sense. And I think the legal community, the judiciary, and all the entire legal community would be up in arms if he did that. And I don't think he's willing to take that risk.
Well, why do you think the judge held off on ruling on the motion then, Titus?
It builds up suspense. It makes it seem like he's seriously taking it under consideration. The judge knows from the moment the defense makes that motion whether he's going to grant the motion with prejudice. He knows that right off the bat. However, if he flat out says no, then the defense will say, well, the judge didn't take it under serious consideration. By letting it dangle in the air, he's making the prosecution think, well, maybe the judge is upset. Maybe the judge is getting tired of what we're doing. Look how serious the judge is taking under consideration. But again, for the judge to actually cross that bridge and to grant it with prejudice is completely different than simply haranguing the prosecutor outside the presence of the jury.
So he's holding it over the prosecution's head in order to get them to act right, CK?
I agree. And he's letting them know, I'm not messing with you. Don't play with me. I think that's what he's doing. But at the end of the day, the prosecution has to do what it has to do. And so does the defense. So, at the end of the day, I just don't think there's sufficient grounds on any level, not even that pushing the envelope constitutionally on Kyle Rittenhouse, silence and all that pre-trial, not even that rises to the level of granting a mistrial with prejudice.
And if I could just add in
CK and Titus. Oh, go ahead, Titus.
I'm sorry, I was saying, really when you get down to the basics of a mistrial, it's essentially saying the prosecution has done something that is so horrible that is completely prejudiced Kyle from getting a fair trial. That is why the grant with prejudice is so extraordinary. The judge would actually have to find a legal basis to say, yes, what the prosecutor did here was so bad, there's no way the jury could fairly determine the verdict in this case, which, as President Hoffler said, there's just no evidence of that in this trial.